Hello, Hannah. So as far as when this is going to start, I mean, court is supposed to be starting in just a few minutes here at 9 o'clock. That being said, it is not unusual at all for the judge to be a little bit delayed in the actual start. So, um, it's kind of like going to the doctor's office. If you're late, you're in trouble. If the doctor's late, you're still getting the bill. Something missing. I put everything in the drink. I should probably check. Are you able to hear me? Um, Seeing someone go to prison today, highly unlikely. I mean, unless there's some major ruckus in the courtroom and someone gets arrested for contempt or something. Um, the trial isn't planned to start until tomorrow and runs through Wednesday. Then we have to deal with the jury deliberations and then the verdict. And even then, um, actual arrest could be held off until sentencing. Okay, thank you for verifying that for me, Melissa. But yeah, today is just going to be more of preliminary stuff that, probably questions, sorting out witnesses and um, questions and stuff like that. Keep in mind, all three of the people that are going to be in this trial have already been arrested. They've already been indicted. They've made bail, so they're out and about until their conviction, if there's a conviction. I have no idea if he was a J6 or not. Keep in mind, I mean, this trial has nothing to do with J6, and I can pretty well guarantee they're not going to let, even if he was there and there's proof, they're not going to let the jury hear that. As we saw when the Alan Swinney trial went through, the defense was able to do a very good job at keeping things laser focused on what he did at the protests. There was very limited ability to touch social media postings that he made before the event or after the event. They had to be very specific, and his past relationships was just something that was not able to be brought up in the trial. Not that us out here didn't know all the stuff, but It's probably worth noting that this case is framing up to be an argument of free speech rights versus state overreach. We've been looking through the court filings. It's been very clear that the defense is claiming that, you know, not only was Mr. Gibson just standing on the sidewalk, you know, albeit taunting, but not actively engaging with the people at Cider Riot. You know, at what point does that cross from First Amendment to inciting a riot? I'm not sure. But then on the other side, you know, they're also claiming that the policy that current DA Schmidt put out in August of 2020 after he took office was supposed to decline to prosecute cases involving just riot that were as a result of the George Floyd protests, and a persistent argument in this case has been that because there was no specific date range put onto it, that this case should also have been declined for prosecution, because the charges in this one were only riot.
Good morning, this is the court clerk. We're not on the record at the moment, but we're about to get ready. This is a reminder that all folks on WebEx need to make sure that they are fully muted with their cameras turned all the way off for the entirety of the proceedings. Thank you. We'll be beginning shortly.
And everything on this end told me the audio was good. So hopefully you guys all heard that as well. And yeah, when court actually starts, I'll be muting my mic and turning my camera on and off periodically depending on what I'm doing over here, so no keyboard clacking from me for you guys today.
The Court of the State of Oregon for Multnomah County is now in session. The Honorable Judge Benjamin Souede presiding.
Good morning, everyone. You're welcome to have a seat. We'll go on the record. Mr. Kalbaugh.
You want me to call the cases, Judge?
Would you please?
We're here in the matters of State v. Gibson, 19 CR 53042, State v. Lewis, 19 CR 53035, and State v. Schultz, 19 CR 53040. This is the time and place for trial, day 4 of this case, and parties are ready to proceed. Defendants are present, represented by counsel. My last name is spelled Kalbaugh. My bar number is 074335. And I have co-counsel next to me, and I believe trial-wise we're dealing with a lot of motions today.
Mr. Kalbaugh, thank you.
Good morning, Your Honor. Also for the state, Sean Hughey, H-U-G-H-E-Y, bar number 152776.
Mr. Hughey, good morning.
For Mr. Gibson, Attorney D. Angus Lee, common spelling. I'll let you.
for Mr. Gibson, James Buchal.
Thank you. Mr. Gibson, good morning, sir.
Good morning. Good morning, Judge. Brian Schmaltz for Mr. Schultz, 053726.
Thank you, Mr. Schmaltz. Good morning, Mr. Schultz.
Good morning, sir. Kelly Doyle for Mr. Lewis, 840394.
Thank you, Mr. Doyle. Good morning. Good morning, Mr. Lewis.
Good morning.
Nice to see everybody back. Thanks to everyone for being back on time and ready to go. To recap where I think we are, we're going to pause jury selection for a little while. We'll take up motions and then we'll pick up, resume and complete jury selection and then take up any motions that remain. I have 3 sets of motions from Mr. Gibson. The first set we largely dealt with earlier, and then there are 2 sets that I think we have not touched on. I understand there is some overlap there. I don't have hard copies of any other motions. Does anyone believe there are additional motions that have been filed and provided to the court that I should have seen by now?
Not that have been filed. I was just going to alert the court that the state will have 2 relatively simple oral motions.
Sure. Okay. Have the parties had a chance to confer? Well, 2 questions. One is, have the parties conferred on the outstanding filed motions? And whatever the answer to that is, separately, has the state had a chance to review and figure out what its position is on some or all of the outstanding motions from Mr. Gibson?
We actually haven't had a chance to confer, Your Honor, and I think, and please tell me if the court feels differently, the state has had an opportunity to review them. I think they can be pruned and streamlined quite a bit, but our preference would be to do that on the record just because
Sure.
We want to avoid a scenario where if a written motion describes a piece of evidence one way, there's any ambiguity.
I don't disagree.
Yeah.
The best plan I have is to just take them up in numerical order and to as a first move for each motion to check in with the state to see what the state's position is, and then to return. And to the extent any other defendant wants to join, we can deal with that. To the extent any defendant has any oral motion that he wishes to present, we will deal with that when we're done with the written motions. So I think that'll be the plan. Mr. Lee, Mr. Buchal, does it make sense then to start with Mr. Gibson's second set?
Yes, motion
Okay.
number 4.
Motion number
And
4 of the second set. Okay.
Yeah, and we kept them in numerical order so that the record should be clear across the 3 as far as what number a motion nominee is.
Okay, thank you, Mr. Lee. Okay, so motion 4 is a motion from Mr. Gibson that seeks to bar the state from playing, quote unquote, the 2 bridge videos during the trial. Does the state have a position?
I think so, but first I just want to confirm that the term 2 bridge videos, I interpret that as referring to what the state identified on its exhibit list as exhibits 6 and 7, which are titled YouTube Rewound News 3 in the case of exhibit 6 and YouTube Rewound News 4 in the case of exhibit 7. Is that what the Mr. Gibson's counsel means by the 2 bridge videos?
Does the court want us to stand up and down
For these purposes, if sitting is easier, and I suspect it will be, that's fine with me.
Yeah. Thank you, Your Honor. I believe those are the correct exhibit numbers, but just for substance, they're the 2 videos that are not showing the location of the cider bar there at the bridge.
And if I remember from many months ago, it's an earlier time, same day at a different location.
Yes.
At an earlier time.
And they do not show Mr. Gibson or Mr. Schultz at the bridge.
Right. The state is willing to is not going to offer what it's identified as 6 and 7, which are the 2 videos titled YouTube Rewound News 3 and 4. And I think that makes motions 4 and 5, but Mr. Lee, please tell me if you disagree.
I was going to set up in case somebody needs to play.
Yeah. 6 and 7 overall. Yeah. Is the court waiting to hear from me on the other ones, or are we going to?
No, just, so Mr. Hughey had suggested that also resolves motion 5. That is my sense also, but I want to know if you disagree.
And I tried to make these motions in such a way that a bigger motion may clear a few of them. Yes, 5 and 6, the thrust of those was also limiting the bridge videos.
Okay, so then
4 and 5.
I'm sorry, 5.
4 and 5.
Yeah.
Okay. 4 and 5, then I understand are not, Mr. Yu, I think you said they were rendered moot. I think they're unopposed, so I'm just going to grant them as unopposed. And those videos will not be played entirely or in part.
So 4 is granted without objection,
Correct.
and then 5
is also granted as unopposed.
As long as, and I think everyone is clear on this, but as long as everyone is clear that those relate to the exhibits identified by me and numbered 6 and 7, not, you know, if there's any argument about videos being characterized differently that are within the scope of this, that may change things.
I understand. I think we have a clear record on that.
Okay.
Mr. Gibson's motion 6 is a motion to prevent the state from introducing any portion of any record of any recording that includes hearsay. So this is essentially the Oregon Rules of Evidence should apply motion.
Right. We certainly are not opposing the application of the Oregon Rules of Evidence. We all know that. But I don't think there's any practical way to really rule on this motion. Obviously, this is going to change with the piece of evidence by piece of evidence, whether some characteristic makes it non-hearsay or a hearsay exception applies. We all will be bound by the rules of evidence in this trial.
Okay, thank you, Mr. Uri. Mr. Lee, I think I need a little more spin on the ball to figure out what this motion is directed at.
Sure, thank you, Your Honor. I'll start by saying that motion 6 was, the thrust of it was the 2 bridge videos.
Okay.
That was the primary thrust of it, but it was not the complete motion. The issue is the state's case is largely a series of videos, and in those videos there are a series of people that will not be coming to testify. And those people who are not coming to testify, who will not be subject to cross-examination, make a series of statements, particularly before the...
So is it a confrontation motion or is it a hearsay motion?
Primarily a hearsay motion.
Okay, so whether or not they're here to testify doesn't sort of go to whether or not that piece of evidence is admissible if what we're talking about is hearsay.
Right. And the issue is what the state could do is they could take the exhibits, and it's very simple. You just hire an audio video tech to mute during the hearsay statements. So that's our concern, is they're going to play videos where they have hearsay, you know, Mr. Gibson X.
Okay.
You know.
Let me take us up one level of abstraction just because I want to make sure we're talking about the same thing. Okay. I've obviously seen some or all of the evidence.
Right.
So certainly there is video evidence of people saying and doing all kinds of things.
Right.
My sense is in general you're not moving against that evidence. What you're moving against is where there are particular statements that might go beyond simply the fact that somebody said it, but might be offered for their underlying truth. For example, attributing a desire or a statement or an action that happens off camera to Mr. Gibson.
Yes.
Okay.
And again, that is kind of ongoing in the videos. It was primarily in the 2 ones that are out. So I didn't list all of them out, unfortunately. Right. Okay. But I think if the court gives guidance on this issue, then the state can, and we can talk about that, and they can go to an audio expert to just void those portions of the audio.
Or, I mean, we literally have a remote control. So, Mr. Hughey, I take seriously Mr. Lee's point, which is we're going to have videos, there's going to be lots of things and lots of people saying lots of things. This motion does not say those things don't come in. This motion is directed to particular articulated statements that would be potentially received for their truth that assign some action or intent to Mr. Gibson.
Right. I think I would propose that maybe a better way to handle this would be to, I suspect we're going to need to spend some time today talking about these specific exhibits that either the state will offer or maybe they'll be stipulated to, and whether any redaction or trimming need to be applied before they're received by the court. It would make sense to me to handle this motion in that context.
I think that's right. So I'm going to defer on motion 6 for now. I understand the import of it and the thrust of it. Let's deal with it when we're actually into the videos. Motion 7 is a motion to prevent the introduction of testimony that from
Ms. Clark.
okay from a person who would be anticipated to testify that during the incident she suffered an injury, in particular a concussion or a bone fracture. I understand the basis of the motion is that this person herself is not qualified as an expert to give a medical opinion as to what was her diagnosis.
Yeah, that and Your Honor, I think I actually came back to this in my third set later, and so I should probably flag now. The other reason is that it's irrelevant to the factors that the court has, that the jury has to consider in this case. And obviously the jury is going to see video that shows a person who's not a defendant in this case strike her. What the impact of that strike was physiologically is not for the jury, totally prejudicial, and she doesn't have independent firsthand knowledge. She's not a radiologist.
Okay, so I understand there are three bases for this motion as also re-articulated. Motion number 1 is she lacks a qualification to give this testimony. Number 2 is a relevance objection. Number 3 is a 403 undue prejudice.
Yes, Your Honor.
Okay, thank you.
Thank you.
I think we can say that the state concedes this motion. We're not going to offer any or try to offer any technical diagnosis without proper foundation. Any witness, including Ms. Clark, would be limited to her rational perception. And just to be totally candid, we're not going to try to call a doctor or admit medical records because I agree that's not the thrust of this case.
Okay. I suspect Mr. Kalbaugh is talking about the thing I was about to ask. Yeah. Go ahead.
And so that is why I pointed out that she certainly can testify about her rational perception. And so testifying about an injury or being rendered unconscious, we think is within the scope of what she could testify.
Okay.
And don't intend to concede that in saying that we concede this motion the way I read it.
And that goes beyond at least motion 7,
I think so.
which is directed at the diagnosis. So, Mr. Lee, to the extent that the state is agreeing, no testimony where she's sort of medically identifying what she was diagnosed with after the fact. That's as far as motion 7 goes.
Yeah,
right?
as far motion 7 just says she can't get on the stand and say, "Oh, I had a broken vertebrae or fractured bone or anything like that."
Okay, I think we're on the same page though.
Or a concussion. She can say she was lost consciousness.
Here's what happened to me. Here's what I saw. Here's what I felt. Here's what I. Okay.
But she can't diagnose a concussion or a bone fracture.
Okay.
He didn't hit her. He didn't hit her.
Your Honor, isn't under the 403 is unduly prejudicial, and that none of the 3 defendants here today had anything to do with her injury?
I'm sorry, Mr. Doyle, are you now presenting an oral motion even to exclude what she rationally perceived on the day?
I am.
Okay. Mr. Hughey.
We would oppose that as well, Your Honor. With respect to these defendants, one of the elements the state has to prove is that the conduct that they engaged in created a grave risk of causing public alarm. And in many ways, the culmination of this incident, or one of the most damaging culminations of this incident, was the injury sustained by Ms. Clark. And so in our view, that is part of essentially the risk being realized. Public alarm, absolutely.
But of course, realization is not an element; it's only alarm.
Right, but it strengthens it strengthens the proof of a risk existing if the risk is realized. Of course.
Does it go to 5 or more persons element?
It can as well. That's another basis. I mean, I shouldn't say it can. It does as well.
Okay. All right. Mr. Doyle, do you wish to be heard again on your oral motion?
Yeah, I still think it's really unduly prejudicial because the one injury has been dealt with another defendant. And to bring that injury against our people who really, and I guess that's one of the issues that we're going to have to deal with, is that they had anything to do with this or wanted to. I mean, I think, according to my understanding, some of our people have already been out of the picture by the time this occurred.
Okay, thank you.
and it's just unduly prejudicial.
Okay, the oral motion is overruled. I think, at least as I understand what the evidence is likely to be, this evidence is highly probative on both whether 5 or more people were involved, as well as on whether these defendants' conduct gave rise to significant public alarm. I'm open to a limiting instruction if somebody would like to propose one when we get closer. At the same time, I think that it will be plain to the jury that none of these defendants committed that act, such that I think the risk of undue prejudice does not substantially outweigh that probative value, which I think is significant. Moving to motion in limine, Mr. Gibson's MIL 8. That's a motion to prevent the state from introducing testimony that
And there's a typo in there.
should that be Mr. Lewis?
Yes, Your Honor, thank you.
So it's a motion to prevent the state from soliciting any testimony that anyone was harmed or offended by any of Mr. Gibson, Mr. Schultz, or Mr. Lewis. So it's the idea that any witness can testify that someone else was offended. Okay, sorry, it took me a minute.
To the extent that this is a motion to prohibit speculative testimony, we wouldn't oppose that. I think there may be a scenario in sort of an instance by instance application where somebody could identify a portion in a video and say, you know, that person appears to be injured because you see this thing hit them, and then they double over in what appears to be pain, right? That's just sort of common sense observation. That may also sort of touch on the court's other rulings about somebody narrating the video. So I think in practice, this is likely not to arise, but because I identify that instance of just a reasonable inference from observing somebody's actions, I don't want to concede the motion, but certainly would concede that the state will not attempt to offer speculative testimony or attempt to have a witness narrate video.
Right, we've already talked about narration. I can see a very narrow lane where a witness might be qualified to say something that could be covered by Motion 8, but Motion 8 is largely correct.
Right.
And so...
Could I suggest that...
Go ahead.
Could I suggest that it be, with the recognition that it's largely correct, that it be granted with the recognition that if the state wants to go beyond that, they can just advise the court?
So that was what I was about to say.
Sorry.
Is that no, I don't mind you saying it. I think the default here is going to be no questions asking about someone else's physical or mental condition without giving the court a heads up that that's a question the state intends to ask, so that we can deal with it on the particular merits of the particular thing.
Understood. Thank you.
Thank you. Just keeping my notes up to date.
And just to alert everybody, the exception that I could foresee, or the instance that I could foresee where that would become at issue, would be if a witness were testifying about something that's, you know, just out of frame. And you know what, when I was filming this, this happened over here.
Right.
Or yeah.
Yep. Motion 9 is a motion that to bar the introduction of testimony. And by the way, each of these motions is directed as a bar to prevent the state from doing something. Obviously, good for the goose, good for the sauce. These are not one-way rulings. To the extent evidence is excluded, it's excluded as to all the parties.
Thank you for clarifying that. I was going to make that request.
So motion 9 seeks to bar the introduction of testimony regarding statements made by other people to police officers. So I assume this is largely statements contained in police reports or something that an officer would testify
Yeah.
that they were.
Yeah.
Okay.
And there's just 2 officers.
Right. Again, I think this is largely a motion to enforce the rule against hearsay. If there are non-hearsay purposes to admit a statement, that may be admissible. I would propose that the court deny the motion, but obviously continue to enforce the rule against hearsay as it will.
So I think that's the right thing to do. The court will enforce the hearsay rules. Statements to police officers that qualify as hearsay are prohibited, not by this motion to eliminate, but by the Oregon Evidence Code. Statements that are not hearsay and are otherwise admissible are otherwise admissible, which I think compels me to deny the MIL, but with the understanding that hearsay is out.
Unless an exception applies, of course.
Well, sure. Inadmissible hearsay is out.
And, Your Honor, could I go a little more on that?
You may.
The reason I bring this motion is in large part because we've got 2 law enforcement witnesses in this case. Souede, if I'm pronouncing that correctly, and Trainer. By and large, Trainer's involvement in this case was he compiled some video, and then he talked to a bunch of people and gathered nothing but what would be hearsay evidence. And so to the extent that he is going to be called to do anything other than authenticate video, it seems like it's just basically all hearsay, and the state's saying, well, they may have some hearsay exceptions, and instead of doing all this in front of the jury, I thought it would be a time for them to say what that might be.
Fair enough.
I don't think the detective trainer is going to do anything that would implicate the purpose of this motion. And if that's helpful to Mr. Lee, that I don't think we're going to try to do what you're concerned we're going to try to do. But I don't think the court should change this rule.
Here's what I'll say. The state should not attempt to introduce inadmissible hearsay evidence. If it thinks that it's going to do something that it knows or reasonably should know is close to the line, do it outside the presence of the jury, and we'll deal with it then. I agree that, and I don't think the state intends to do this, but a litany of this statement and then we have to argue about it, and this statement in front of the jury and then we have to argue about it is not productive. We're not going to do that.
Yeah.
But I think that suffices for now. Motion 10 is these days fairly standard motion to omit the word victim from any lawyer, or actually this one just goes to testimony. Either there's another one, or I assume the intent is to also capture lawyers talking.
Yes, Your Honor.
To use from using the word victim.
Oh, I'm sorry.
What's that?
And the court.
Sure.
Yeah, I think this motion is controlled by State v. Spurue. I'm not opposing the motion, but just noting that Spurue, and I think the proper ruling on this motion is limited to characterization by lawyers or witnesses during the evidence. Spurue does not go as far as to limit that characterization in the closing argument, although this is also a case where no victim is pled. It's not an assault case, so I don't expect that to be an issue.
Right. I agree with all of those things, and so construed, motion eliminate 10 is granted. Motion 11 is a motion from Mr. Gibson to prevent testimony that any defendant's conduct was reckless or that any defendant acted recklessly. I understand the thrust of the motion to be that is a factual issue for the, it's a reckless carries a legal definition. It is the jury's job to determine whether or not the facts are such that the definition is met or not met.
Yeah, I understand it the same way, and we concede it for that reason.
Okay. Motion to eliminate 11 as so understood is granted. Motion 12 seeks to prevent the introduction of testimony from any witness that any defendant's conduct was intentional or that any defendant acted intentionally on the same basis as the reckless.
And it's conceded for the same reason.
Motion 13 seeks to prevent the introduction of testimony that any defendant's conduct created a grave risk of causing public alarm on all the same bases as the previous two motions.
Yeah, understanding that the big distinction here is testimony versus argument, the motion is conceded as well.
That's how I understand the scope of the motion as well, and so construed, motion 13 is granted. Motion 14 seeks to prevent the introduction of testimony that any defendant was participating with was quote unquote participating with 5 or more persons. I think largely the same legal basis for the motion.
Yes, Your Honor.
Yeah, I think this is a little bit more nuanced. I agree. I appreciate what the court is recognizing with the question of participation being an element that touches on the ultimate issue. But the only reason I'm not just conceding this motion outright is because I think there can be a scenario where somebody could say, yes, this person walked up with 3, 4, 6 other people. That testimony.
What the motion really turns on, I think, is a witness. I think what the motion is directed at, Mr. Lee will tell me if I'm wrong, is a witness sort of using the technical legal definition that is the element of riot, as opposed to saying, yes, these 2 people were together, they were doing this together. Yes, these 3 people walked over as a group. It is to prevent the state from asking a question. I'll pick on Mr. Gibson since it's his motion. Was Mr. Gibson participating in this with 5 other people? Do I understand the scope of the motion correctly?
Yes, Your Honor, thank you.
Okay. And the way, sorry. Yeah. Right. Understanding exactly what the court recognizes as improper, we would concede that, and we anticipate submitting a special jury instruction to define participating with.
Okay. It's certainly something we're going to have to talk about.
Oh, yeah.
Okay. With that motion as so construed, which I think Mr. Lee has confirmed is the correct construction, motion 14 is granted. Sorry. Okay, motion 15 seeks an election of facts. Mr. Gibson is requesting that the court require, pursuant to this motion, that the state elect the specific facts, and by facts I think behavior, actions,
Yeah.
Actions by Mr. Gibson that were violent and tumultuous. The motion also extends to Mr. Schultz and Mr. Lewis. I understand the motion is not being made on behalf of Mr. Schultz or Mr. Lewis, but that because it's a 5 or more person standard, that Mr. Gibson would like the court to require the state to identify all of the all such actions.
Yes, Your Honor.
Prior to the opening statement.
Yes, Your Honor.
Mr. Hughey, this one's a little involved, so if you need a minute, I understand.
No, I think I have a case for the court that I think is pretty helpful. State v. Payne, 298 ORAP 411. It's a 2019 case. Judge James wrote an opinion where he really went to great lengths to clear up when we talk about election, we can be talking about 2 things. And he distinguishes between the notice-based election, sort of pre-trial, where a charging instrument might survive a demur, but nonetheless not give appropriate notice. I think most commonly the cases used as examples of that circumstance are like a number of sex assaults where there's repeated conduct. Somebody commits 1,000 sex assaults, 10 are pled, and it's not distinguishable. The second is essentially to ensure unanimity, to ensure concurrence in the evidence. That's what I interpret this motion to be moving for. In any event, even if an election were required, it would not be required until the end of the evidence. However, I don't believe that the alleged crime of riot is so narrow as that it requires the state to allege a single act, right? This motion or this moment, or this step, or this push, or this shove, right? The state's theory is that the entire episode, about 40 minutes, is the conduct that will support the charged crime. And that's exactly the conclusion the court reached in Payne. That was not a riot, that was menacing, I think.
We're going to go deep on this when we get to jury instructions.
Certainly.
But for now, does the state agree with the notion that that the crime of riot requires some physical act?
I think the crime of riot is controlled by the legal definition and the jury instruction of violent and tumultuous conduct, which starts with.
Okay, but Jakarian tells us.
Yeah, and
that,
say shall.
Right. Okay. I guess. Is the state's, on this motion, is the state's argument essentially Mr. Gibson is on appropriate notice because you were saying this 40-minute window contains all of the things?
Yeah, we've been
which is different, I think, from what you said. I'm sorry to ask you a question and then cut you off. But what I think I heard you say initially was the 40 minutes is the conduct. But I don't think the state's theory in this case is that every second of every minute that Mr. Gibson was there, he was engaging in violent and tumultuous conduct. Or is that the state's theory?
Well, I think you may be able to identify, moments where okay, that particular moment is not violent and tumultuous, or there's a pause or an interruption, but not to the extent that it makes it a separate episode. Nothing okay. Anywhere near that. So from a notice.
So in closing arguments or on a motion for judgment of acquittal.
Write it down and hand it to me.
Well, we'll start with in closing arguments. Your intention is to get up in front of the jury and say, look at these 40 minutes.
Right. Absolutely.
This is violent and tumultuous.
Absolutely.
Okay.
And that there is no singular, moment where this is the moment that the jury all has to concur on. Right? That the conduct.
Well,
broader.
The jury does have to concur on which conduct was violent and tumultuous.
Absolutely.
But your point is that doesn't have to be a singular moment in time?
More narrow than the 40-minute window is what I'm saying.
Okay.
Yeah.
All right. I'm not passing on that question at this time. Mr. Lee, do you want to be heard?
You're on. Oh. Yes, Your Honor. We're not in a factual vacuum. We're in the situation where the court's seen the video that we're talking about. And we're also not in a case that's divorced from First Amendment freedom of association issues, freedom of expression issues. We're in a case where somebody's clearly engaged in First Amendment activity. And we are going to need, in this case, a jury instruction that separates out to make clear that the jury doesn't find him guilty based on First Amendment conduct. And they're going to have to unanimously agree this was the conduct that he engaged in. Now, we're going to get to that point at some point before we get to the jury. The issue is, as we sit here right now, we have still, to this day, no idea what the conduct is in that window that they say is violent and tumultuous. And we come back again and again and we hear the argument, and there's no specific, he threw a punch, for example. And so when you look at State v. Antoni, if I'm pronouncing that correctly, Antoine?
Yeah.
Thank you. That we cite to in the motion, what they say is the defense is entitled to tailor their defense to the specific incident, and that, quote, elucidation of the state's precise theory at trial does not cure the problem of a lack of pretrial notice. End quote. And the reason that they go on and give is because I've got to make an opening statement that addresses the most pertinent facts of the case. I've got to make a cross-examination that addresses the most pertinent facts of the case. I've got to have Mr. Gibson testify and address the actual thing he's actually being accused of. And to this day, it's still a mystery. Right. And the case law that we've cited throughout is that in a First Amendment case, the danger of a conviction based on First Amendment conduct is very serious. And so that's why we needed to know a long time ago. And when we addressed this a long time ago, we were told we would get that election of facts in time to develop our defense. Here we are, we're making opening statements tomorrow. We don't know what it is, and it doesn't sound like the state does either. So
the state absolutely does, and the defense does as well. It is in the discovery they have had for years. It is the episode. That is the conduct supporting the charge alleged against your client.
And I think we had this conversation maybe as long as a year ago.
Yeah.
The state's theory of the case, as I understand it, is and we're talking about Mr. Gibson because he's the moving party. Mr. Gibson arrives at the scene and begins engaging in the crime of riot upon his arrival.
Correct.
The two issues, if I may, Your Honor. All he does when he arrives is stand on a sidewalk and live stream. And as it relates to the state's requirement that they prove what 5 people did that was riotous, Mr. Schultz is observed the entire time doing nothing but being present. I would really like to know what it is Mr. Schultz did in that conduct.
So
Argument.
the disconnect here a little bit, I think, is Mr. Lee, on behalf of Mr. Gibson, you have a very clear legal theory of what may or may not actually constitute a crime. And you're entitled to the benefit of that theory. You may be entitled to a ruling, ultimately, that your view of the law is correct. What I don't think that entitles you to is to have the state depart from its theory of what it thinks is legally appropriate. I think the state has sufficiently identified what it thinks the riotous behavior, the behavior that qualifies as riot, is. If the state is wrong about that, you may be entitled either to a jury verdict or you may be entitled to a court ruling that that does not qualify. But the state having made that choice, I think you are on appropriate notice for what it is, what the things are that you are tasked with defending against. And so, for that reason,
Your Honor, may I be heard on
Mr. Doyle?
I'm
sorry. I'm denying Mr. Gibson's motion 15. Mr. Doyle.
Well, I guess I'm right now in the way of 50 ways to beat a dead horse, but I am really concerned in the video and in the facts that some of the people that are contributing to the riot are on the other side, if there is a riot, are on the other side, and that their behavior escalates this event. And when we say conduct, all I keep hearing is what's on the video. I've seen the video more than once. And the conduct by our people, I'm going to say our people, but our people in many cases is reactive to a lot of things that are happening to them and is not at all contributing to riot, but that there tried to be a peaceful confrontation and acts by other people of other parties made whatever happened much worse. And I think what we are asking for is at least what punch was thrown or what actually occurred, because what we are given is a bouillabaisse and we're trying to pick out the clams, and it is very hard to do.
Mr. Doyle, I'm hearing two things that you're arguing. The first is, I think, a suggestion that the 5 or more persons provision of the riot statute is not satisfied if you have 5 people together, from 3 of whom are from one point of view, two from the other, and they are engaged in sort of mutually hostile behavior. I don't have authority for that. If that's an argument you want to make, I'm going to need a little more authority for that proposition. The second point you make, I understand, is overlapping with Mr. Lee's, and it is that notion that you are looking for individual acts that you think the state has to say that right there when he took that step and did that thing that's violent and tumultuous. Again, I think the state has identified, consistent with its theory of the case, what it believes constitute the crime of riot. The state might be wrong about that, but I think it's sufficient to put Mr. Lewis on notice. I will also say, at the end of this case, I absolutely agree with the notion that I think is implicit in these arguments, but maybe we're earlier, maybe it's just literally early in the life of the case. A concurrence instruction in this case is appropriate. The jury needs to agree as to each defendant. In order to find that defendant guilty, the jury would have to agree about particular conduct that was violent and tumultuous with respect to that individual defendant. That is absolutely the case. But that, I think, is a jury instruction issue, and I won't hide the ball. That's an instruction the jury is going to get in this case.
Judge,
Mr. Schmutz.
that is how I'm looking at the issue. I'm actually working on it right now based on the Camp House case from 2021.
Sure.
Which is very explicit that we are going to be entitled to a concurrence instruction, and I will be asking for that when we get to the jury instruction.
I'm very confident you will, whether or not it's in the form you're proposing, such an instruction is going to be given in this case. That brings us to Mr. Gibson's motion 16, which seeks to prevent both testimony and argument from any party that any particular defendant's language or words were themselves violent or tumultuous conduct, as that term is expressed in the statute.
I think the state is not opposing that motion, but I just want to make sure. With respect to testimony, of course, this dovetails right in with the court's prior rulings about.
Certainly.
And with respect to argument, obviously the state is confined by what the law is, and there is a legal definition that the jury, I expect, will be instructed on. Uniform Criminal Instruction number 2300 sub 6, which defines violent, tumultuous, or threatening behavior as physical conduct that is immediately likely, etc. So I think this is essentially a restatement of what the law is, and would expect the court to enforce that.
Would the state anticipate? I agree with all of that, and that motion will be granted on understanding. And then there's another step that it may be productive to talk about now, and if I'm wrong, we'll stop talking about it. But I do not hear the state saying that speech that was occurring contemporaneously with conduct is irrelevant to interpreting that conduct.
I would say the opposite of that.
Okay,
so that's highly probative.
So just so no one's surprised,
yeah,
the state would anticipate eliciting testimony potentially, but I'm not quite sure how that would work here, but at the very least making argument that the physical conduct of a defendant, to the extent that the jury is charged with interpreting the meaning and intent behind that conduct, that the jury may use the words of that defendant contemporaneous with that conduct to do that inferential work of relating to the physical conduct.
Unquestionably, they can, and we will urge them to.
Okay, and I agree that is outside the scope of the motion, which is really the way I should have been asking that. So understanding that that's outside the scope of the motion, motion 16 is granted, and I understand is not opposed. Next is Mr. Gibson's motion limine 17, which seeks to prevent the introduction of testimony or argument by an attorney that any defendant's language or words incited others to engage in violent or tumultuous conduct. And I assume the thrust behind this is largely that this is not an incitement case.
Correct, Your Honor.
Thank you.
There's certainly no objection to the component of the motion that seeks to bar any testimony to that effect. I think that would be the same in line with the court's rulings about and the evidence code's prohibition against speculative testimony. I would oppose the court saying that no argument could be made about language or words, prompting other people to do things. And really that's just another way of, I think, saying inciting, right? But in the same sense that it would be limited to interpreting the intent of physical conduct.
Help me a few more bars of that.
Well, so I guess to use an example that's probably somewhat similar, but it is not intended to be from this case. If two people are standing in front of one another and one is lunging at the other person's face going, what are you going to do? Hit me? What are you going to do? Hit me? And then a physical confrontation ensues. It would be completely appropriate, and if that were a component of a riot charge or evidence supporting a riot charge, it would be perfectly appropriate to argue, look, when they do that conduct and use those words, that is inciting or causing.
Okay, so in argument, the state sort of connecting dots.
Yeah.
In terms of the timeline and what happens, and saying this is why, in the state's view, this next thing happened.
Absolutely, and that's the distinction I think is important, the testimony versus argument. I agree with everyone that the charge here is riot, not inciting a riot or anything like that.
Okay, so instead of Mr. Gibson and Schultz and Lewis, defendants A, B, and C, in closing, you would argue that you have the right to get up and say, defendant B walks over to defendant C, and you can see them talking, and then you see defendant C doing a thing.
Absolutely.
Okay, and why is that, in the context of what the charges are in this case, why is that anything that is, why is that an appropriate argument to the jury? Help them understand what?
Yeah, in the same way that the words or speech in motion 16 contextualize the conduct.
Okay,
and only contextualize the conduct and also support the mental state for the accompanying conduct.
Okay. I think I agree with that exception to motion 17, but I'm happy to hear argument.
Well, the problem here, Your Honor, again, we can't lose sight of the fact that this is it's a First Amendment case. And when we picked the jury, we heard a lot of talk about incitement. And this is not an incitement case, but there is a general view in the public, not just locally, but across the country, that there's a thing that's tantamount to riot called incitement of riot. And there's this general public perception that you can incite a riot and therefore be guilty of riot, which is my concern, just by your language or words that other people disagree with or that other people find offensive. And so when we get into saying that their words incited somebody to do something, it's one, speculative. You don't have any way of knowing what they intended by the words, and you don't know it was inciting. And then even if you get to incitement, it's just so dangerous in a riot case with what we've all seen in the media about discussions of incitement to allow it to go down that road and even, frankly, use the word incitement.
Okay.
So that's the concern.
Okay. I think this is the line I'm going to draw. Mr. Schmantz.
Go ahead, Judge. You probably have something that's going to make me want to sit down. So.
We'll find out. The line that I'm inclined to draw, subject to hearing from Mr. Schmantz if he wants to be heard, is to say, of course, testimony, the motion is granted. With respect to argument, I will not abide any argument that any defendant incited, use the, no one's going to be allowed to use the word incite. And certainly no argument that a defendant is guilty of riot because of something they said. So that is to say, we're not going to sneak in an incitement of riot. We're not going to encourage the jury to find anyone guilty on the basis of incitement. These defendants are only charged with the crime of riot. But I do think that there are contexts in which it is appropriate meat for argument for a lawyer to argue to the jury that this next thing happened because of what was said. And that's how you know what was in the actor's mind, for example. Again, using hypotheticals, if defendant B tells defendant C to go do a thing and then defendant engages in conduct that looks consistent with that thing, to the extent the jury has to make a decision as to whether or not defendant C intended something by that conduct, that argument is appropriate, that yes, you can infer that defendant C intended that conduct because of what defendant B had just told him. So that I think is the appropriate line. Mr. Schmantzes, do you seek to rise?
I think I understand your ruling. I just think, having brought this to the fore, then the state is on notice. If they argue incitement, it's a mistrial.
I'm not going to make a per se ruling in advance, but what I will say is, if the state argues incitement, they are outside the bounds of what is permissible in this case.
And just very simply because we have the definition of what violent tumultuous conduct is, and it's not speech. Unless I'm oversimplifying.
Correct,
right.
but
you can contextualize actions with speech.
Exactly right.
I understand.
Go ahead.
I'm trying to
It's
be
okay.
the only one talking for
No,
our.
I don't mind, Mr. Buchal.
Okay, you had something to say.
Thank you, Your Honor. As I understand what Your Honor is saying, that it's relevant to show that the words caused someone else to act?
I'm giving one example of a context where it might be relevant. There might be others that I'm not coming up with on the fly. But a context where I think that is relevant and appropriate argument is where we are evaluating defendant C's conduct. Okay? What was defendant C doing when he walked over and did a thing that he did? What was his intent? I agree with the state that one way from which we can infer what his intent was when he went and did that is, well, did defendant B just say, hey, you should go over to do this thing to accomplish this goal, right? That when we're looking at defendant C's conduct, what defendant B said to defendant C might be a way that we can interpret what defendant C's intent was.
And so the ruling would not apply to, this is about defendants talking to each other, not defendants talking to Antifa.
Yeah,
That's the issue, because the First Amendment principle relates to the insulation of people from.
Well, so I don't know how the intent of a non-defendant in this case is relevant, except to the extent it goes to the 5 persons element of riot. So I'm hard pressed for your example, I'm hard pressed to see an avenue towards relevance.
And we're in agreement on that, Your Honor, and our concern was, especially with what came out in the 3 panels, is that there are some jurors and some lawyers that believe that if you're protesting and then somebody else hits you,
I see. That if you show up, okay, and without attributing any intent to any defendant in this case, in the abstract, the defense is concerned about the notion that a juror might think and might be encouraged by argument that if you get in someone's face and you get punched, you're the one who got in their face.
Right.
And so it's quote unquote on you. That's the animating concern.
Yes,
And
along
I
with what we've
join in
already
that.
discussed.
Okay.
Thank you, Your Honor.
Okay, I appreciate, sorry to be a little slow. Any response, Mr. Hughey?
I mean, I interpreted the court as just offering a hypothetical that illustrates its ruling. Is the court changing?
Well, I guess, I think the defense concern, and I don't know if it's articulated in this well, as I now understand
Done a better job.
no, that was not that's not what I meant. What I understand the animating force to be behind the defense's motion is. So yeah, I mean, the ruling is the ruling, the line is the line. I'm now talking about a slightly different thing. It's sort of a sotto voce self-defense, defense of initial aggressor, right? Even though those technical things are not involved in this case. But the idea being, the defense is concerned that the state might argue to the jury, this defendant said something that someone on the quote unquote other side of the fight found offensive, that caused that person to do a thing. That means that act of speaking the offensive word is an act of riot.
I think I understand the point to be that even if that offensive word that provoked the physical thing, still a word.
It's still a word.
And probably still outside the scope of the legal definition of violent and tumultuous conduct for that reason.
And therefore the state can't say, sure, this other person threw a punch, but it's only because this defendant used that word, therefore it's the defendant that's guilty of riot.
I understand that.
Do you agree with that?
I think I do.
Okay.
Yep.
All right. Okay. I don't think that requires a different ruling on the motion. So the ruling will be as I articulated it. Motion 18 seeks to prevent the introduction of testimony or argument that a defendant holds or has expressed, quote unquote, extreme political views. So it's the characterization that is being moved against.
Yeah, I mean, if what's seeking to be excluded is somebody characterizing really anybody's political views as extreme, that's fine. I'm fine with barring that word from the trial.
Okay. That's how I read the scope of the motion.
And I would ask, I know the court already said this, but I would imagine that applies to the way any witness for the defense might describe any other witness or party's view in the case.
I was just going to make a suggestion in order to, nobody wants a mistrial, but when Ms. Clark is called, it might be helpful for the court to have a colloquy with her.
Oh, 104 or just an admonishment?
An admonishment.
Okay.
She's obviously very passionate about not only her beliefs, but against our client's beliefs. And my concern would be she's going to not listen to, I know two experienced attorneys are able to tell their witness what not to do, but they don't necessarily control them. So I think that could be helpful, having had a few mistrials recently on those issues.
Thank you.
I don't disagree with that at all, and I'll note for everybody that to the extent this court's rulings on these motions apply to things a witness can say, we're going to reduce that to writing and caption it witness instructions and make sure every witness has it verbatim. And if the court wants to do admonishments, I'm all for it as well.
I'm hearing a request as to Ms. Clark only, and I'm happy to do that if people think it's productive.
We also think there may be times when leading questions are appropriate to navigate these minefields.
I can foresee such a scenario. Let me hear from Mr. Lee, and then let me go back to Mr. Hughey's point.
Your Honor, I understand the court's earlier advisement that what's good for the goose is good for the gander. I don't think that's always the case as it relates to the rules of evidence. Some way they're single direction. And the reason we bring the motion on extreme political views is to defend their constitutional rights.
No, and that's, sorry, I don't mean to cut you off, but that's the point I was going to. Let me see if I can do it efficiently. And
yes.
What I anticipate the argument would be from each defendant would be, it may be necessary in explaining why defendants went to the place that they went to and took the actions they took. It may be necessary to explain how they viewed the folks that they were going to confront. Mr. Hughey, do you agree or disagree with that notion?
I'm sorry, will you say that one more time?
Sure, I beg your pardon. I know you're multitasking. So this is to your request that no witness be able to characterize the folks who were present at Cider Riot, their views as extreme or similar. The point I think Mr. Lee was driving to that I've anticipated is, well, to the extent a defendant testifies, it may be important to that defendant's case to explain why they felt impelled to go to the place they went to and do the things they did. And that probably involves their view of those other folks' view. Is that the sort of thing you were seeking to exclude?
I think what I was seeking was that if we're just uniformly excluding the characterization of views as extreme, that can be done universally. If a defendant wants to say, I disagree strongly with them, here's why I went over there, I think it's pretty easy to do that without saying they're extreme. Okay. Right? It's not a pointing match of who's extreme. No, you're extreme. Okay. That's what we want to avoid in this trial.
I disagree with the state on this point. I think for very good reasons, no witness should be able to characterize the defendant's political views as extreme. But I do think it is relevant and constitutionally required to allow the defendants to explain what their motivation was. And so motion 18 is granted as unopposed to the extent the state has now made an oral motion that no defendant may characterize anyone else's views. That motion is denied. Motion 19 seeks to prevent the introduction of testimony or argument that Mr. Gibson is the leader of any group.
We oppose that motion for a couple of reasons. I think that there's a scenario where that testimony is admissible in the way it explains why things are happening the way they are, why certain reactions are generated. And I think there is also likely scenarios where that argument is appropriate in the way that it contextualizes different conduct and reactions to different conduct.
Tell me if I'm splitting hairs too finely. Is there a difference in the state's view between Mr. Gibson, for purposes of this case, between Mr. Gibson being an actual leader and Mr. Gibson being a perceived leader?
No, I think the perceived leader is what the relevant evidence would relate to.
Okay. So Mr. Lee and Mr. Buchal, I know you're also multitasking. I'm not offended. Did you hear my question to Mr. Hughey? If not, I want to repeat it for you.
Please repeat it.
Sure.
Thank you.
My question to Mr. Hughey is for purposes of this case, this motion, is there a difference between evidence that Mr. Gibson is actually the leader versus evidence that Mr. Gibson is perceived as the leader? And Mr. Hughey took the position, in the state's view, what is relevant is that some people see Mr. Gibson as the leader. And his argument is that evidence is relevant in this case. Is your motion directed towards one or the other or both?
Both, and evidence that other people perceived him as the leader is the least probative evidence in this case that I could imagine, and totally prejudicial.
Except perhaps if it helps explain other people's conduct, no?
But other people aren't on trial, and Mr. Gibson is on trial.
But in order to prove riot, the state has to prove that Mr. Gibson acted with at least 5 other people.
Right, and so let's say Miss Clark or Detective Trainer's perception as to who the leader is, that's speculation and it's an opinion. And that's all it is. And so the other issue is that gets into freedom of association. So if you are the leader of a BLM march, does that mean that you are necessarily responsible for what happens when other people show up to your march?
So I think that certainly goes to actual leader role. But again, if people think that Mr. Gibson holds some status, that contextualizes potentially a number of other things.
Well, I think we have, when we say what other people perceive him as the leader, I think when we say, for example, Heather Clark believes he's the leader.
Fine.
How does that inform us as to what Ian Kramer believed. Okay?
Oh, sure. I agree.
Not at all.
Right.
And so that's just becomes her opinion. What we're then doing is opinion laundering.
Well, it would be relevant if
Ian
if
Kramer
Ms.
said-
Clark's view was relevant, then it would be relevant. And you all know better how the evidence is going to come out in this case than I do. But can you conceive of give me a scenario where you believe it to be relevant?
Oh, that's easy. So, hey, in this video, it seems like everyone's acting kind of deferentially to Mr. Gibson. Why is that happening? Well, we perceive him as the leader. Hey, in this video, it seems like everyone's attention is focused on Mr. Gibson. Why is that? Because we perceive him to be the leader.
Who's the we?
I mean,
Who's the person?
It changes. It would change in either scenario.
But whose perception of that in this case would be relevant, and on what issue to be tried?
I mean, if there's people with the other side, so to say, that immediately focus their attention on Mr. Gibson and not somebody else. Well, why is that? Well, we perceive him to be the leader. That's why I'm focusing on that person. That's why.
So it's a matter of explaining what happened.
Right. That's why. Why is everybody kind of immediately yelling right at that guy and not as much at the other people? Well, I think we perceive him to be the leader.
Okay.
And I agree exactly with what the court said about the freedom of association concern is only implicated when we are characterizing or punishing actual leadership, which is not happening in this trial.
Okay.
And the court's asking the right question of who's the we. If we had all 5 defendants in this case, or 6, which we don't, and some of them said, we acted this way because we perceived him as our leader and we were functioning together, that's one thing. But the we that Mr. Hughey kept referring to is actually the people at the cider bar. Their perception of whether or not Mr. Gibson is the leader has no merit to the fact finding of this court. And it's just a way to opinion launder and get in front of the jury this prejudicial conduct. Oh, he's the leader. You heard Ms. Clark say everyone there believes he's the leader. And as a leader, then the natural default is he's in charge, he's responsible for the actions of others. And that's when we get into a tainted verdict.
Okay. Thank you both. Here's where we are on motion 19. The motion's granted in part. There's going to be no evidence as to whether that Mr. Gibson is in fact the leader. I'm going to deny the other portion of the motion, but of course Mr. Gibson or anyone else may object, because I can foresee scenarios where a perception of Mr. Gibson as a leader might be relevant. I can see lots of scenarios where it wouldn't be relevant. That renders that issue not ripe for a motion in limine. I am open to any objection to any question of that type. But for now, motion 19 is granted in part. Motion in limine 20 seeks to prevent the state from introducing testimony or making argument that any defendant was engaged in taunting, or I think it should be provoking a fight. I think on the grounds that it is irrelevant, and that taunting or provoking would be covered as speech, not conduct.
I understand what the court is saying for that purpose, but I think
I'm just trying to articulate the motion as I understand.
Oh, right. So we oppose the motion because I don't think it is drafted as narrowly as the court is expressing it. I mean, if the third element of riot is that by engaging in the conduct, the person intentionally or recklessly creates a grave risk of causing public alarm, taunting or provoking a fight can demonstrate an intent to create a public alarm or a risk of public alarm. So undoubtedly that's relevant and certainly can't be prohibited argument. That reality is kind of betrayed in the third sentence of the motion, where it says one man's taunting is another man's truth saying. That's a factual characterization. That'll be a dispute in closing argument. But to say, hey, you know that this person here intends to create a grave risk of public alarm, Because look at the way they're taunting. That can't be prohibited.
It's totally prohibited. This is a motion about speech. And this goes to exactly what we've been talking about. First of all, taunting or provoking. There's nobody who's going to testify that Mr. Gibson said he's going to taunt or provoke, and nobody on any of the videos said, I am taunting, I am trying to provoke them. So what we're talking about here is Mr. Gibson's speech, and we're concerned, and we had one juror express this viewpoint, or potential juror express this viewpoint yesterday, saying, well, actually, if you go someplace and you're using your words and somebody hits you, then you taunted or provoked them and you're responsible. We heard a few people actually say that in the panel, and this actually kind of follows one of our earlier motions that we talked about with causality, essentially. So our concern is that this is a way for them to argue culpability based on speech as opposed to conduct. And so Mr. Hughey's response makes pretty clear that that's what the state wants to be able to argue, is that his speech was the conduct that created riot. That's basically what he just said, and that's a real problem.
I heard something very different, and it's important, so I want to make sure we get that part right. What I heard Mr. Hughey say, and Mr. Hughey will tell me if I'm wrong, is that what I will call taunting, without characterizing any particular, I'm not making that judgment, but what the state views as taunting is relevant to the jury's determination of whether or not Mr. Gibson intended to cause grave public alarm.
The problem is, when we talk about taunting, are we talking about words? Because the statute only asks if your physical conduct was likely to cause great public alarm, not your taunting speech, only your conduct. That's why them saying his speech was causing public alarm, that's directly the issue of the First Amendment. Directly. Cannot be allowed.
No, words are always allowed to prove mental state. That is not what
But only to mental state.
Right, and that is certainly not what the First Amendment protects. And if I got up in closing argument and said, look at these taunting words, the element of violent, tumultuous conduct is met, ladies and gentlemen, that would be wrong, and an objection would be properly sustained. If I get up in closing argument and say, look at these taunting words, that is how you know what he intended to do, and that his intent was to create a risk of public alarm, that is 1,000% proper, and that cannot be barred from this trial.
I agree. I want to be very, but I want to draw this line very finely. Mr. Buchal.
One thing, I wanted to draw your attention to the word thereby in the statute. It engages in violent, tumultuous and violent conduct, and thereby intentionally and recklessly causes public alarm. And so, given the ruling in Shakarian that violent, tumultuous conduct is inherently limited to the non-speech components,
Right.
Allowing the evidence of speech to infer the thereby intentionally creating the public alarm,
Right.
is a First Amendment problem.
So, hypothetical. Guy walks out of his house and fires, it's 9 o'clock at night, everyone's home, lights are on, and he fires a shotgun into the air in his front yard. Bad example because it's riot. He and his 4 friends walk out with shotguns, and all 5 of them shoot shotguns into the air. They're charged with riot. They've engaged in physical conduct, and the state alleges that they intentionally, recklessly intended to that they intentionally or recklessly created a grave risk of causing public alarm. Same scenario, slightly different. 5 guys, same 5 guys, same time of night, same 5 shotguns. And as they come out, they shout at the top of their lungs, there is a predator drone over the house that we will now attempt to shoot down. And they fire their shotguns into the air. Right? That speech comes in, presumably as part of a defense, to say that they were not intentionally or recklessly creating a grave risk of public alarm. Third hypothetical, I'm done in a second. same 5 guys, 9 o'clock at night, walk out onto the lawn with their shotguns and scream, we are about to go house to house hunting for people we don't like, and shoot their guns into the air. Would not that speech come in as evidence of their intent, as of the intent behind their physical conduct?
So the question is shifting around a little bit. The question that you're asking is, would the speech be admissible at trial? And
which is the question we're dealing with here?
Primarily, we're focused on argument. Okay, argument at trial. And the testimony as well, but primarily argument. The issue is that your factual scenario is totally accurate, it makes sense, doesn't overlay to our trial. Because as we talked about earlier with incitement argument, it's a way, this motion is...
Incitement is out, I agree.
Right, but that's why this should be granted. Because instead of saying, oh, it was incitement, you just characterize Mr. Gibson's speech as taunting speech, as provocative speech in order to get them to respond. And so in your scenario, there's no other side. There's a bunch of people in...
I agree with that. My point in the hypothetical is I think the speech in this case is admissible only for the same purpose that it would be admissible for in my front yard example. That is to say, it is not admissible for the purpose, and I'm going to use Mr. Gibson because it's his motion. It is not admissible for the purpose of saying Mr. Gibson is guilty of riot because he said these things. I think where it may be admissible is Mr. Gibson took these physical actions. Jury, it's up to you to decide whether or not those actions were intended to create a grave risk of causing public alarm. That's the only basis, I think, that the jury could use that on. And I am absolutely open to an instruction that makes that clear. They may not use it for the purpose you are saying. I agree with you on that. I do think the other purpose, and Mr. Hughey, if I have hijacked, if I'm misinterpreting what you were saying it's relevant to, please tell me. But if I have correctly articulated the state's limited purpose, I think it is admissible for that very limited purpose. Mr. Doyle.
Your Honor, and I'm going to remain seated for this, even though I think it's pretty important. I have problems with your hypothetical, and I would change your hypothetical a little bit and see if it matters. Instead of them coming out with shotguns, say they came out with champagne bottles, because those are not lethal, those are not weapons, those are not, and they said, we've been to a party and we want to come and talk to you. Does that change? And you can do the 3 things in the different speech. Does that change your ruling at all? Does that cause you different considerations? Because in my opinion, that is significantly more like what happened here.
Fair. My counter hypothetical would be same champagne bottles, same guys, saying, we hate all of you neighbors, and we're going to come over, and we're going to break these bottles over your head. Right? It's the statement, and that statement, of course, might be criminal for other reasons, but not. I understand nobody said anything like that here. The question is that conduct riotous? And one of the elements the jury has to determine in making that decision is first they have to decide, was the conduct violent and tumultuous? But then they also have to find or decide whether or not in engaging in that tumultuous and violent physical conduct, was the defendant intending to create a grave risk of causing public alarm, or alternatively, were they recklessly doing so? Again, it is not a way to launder incitement evidence. It goes to one of the elements, and what a person says is one of the ways that a jury is able to determine what a person intended. So to be clear, this is a very narrow gap through which this testimony or this argument may be presented. It may be presented, so the motion is granted in part. The only context in which that evidence may be presented or argument on that evidence may be made is as to the mental state of the person who said the statement. As that mental state relates to the charge in this case, which is what did that person intend in their physical conduct if the jury gets that far. Is that clear enough?
It is, and I don't mean to nitpick, but I could see another scenario other than what the court identified. The reckless mental state, which can be an issue, obviously requires the jury to evaluate whether somebody consciously disregarded something they should have been or were aware of. So words that are heard by somebody that then acts can also play into. So I guess what I'm saying is I don't think it's limited to the speaker, because if the question is, does this other actor consciously disregard a risk, and they've just heard other language, I'm never going to say that that language can constitute the violent tumultuous conduct. But I am saying that those words by another speaker could weigh on the conscious disregard of a risk.
We have Cowboy A and Cowboy B at a bar. And Cowboy A says, Cowboy B, if you walk over here, I'm going to punch you in the face. And Cowboy B walks right up. That goes to Cowboy B, the non-speaker's mental state?
Okay, so I think maybe a better example would be, let's say, Cowboy A, B, and C. Cowboy A says, hey, Cowboy B, if you start a fight, this saloon is going to break out into chaos. Cowboy B then goes to Cowboy C and starts a fight. The starting the fight is the conduct, but Cowboy A's statement to Cowboy B weighs on whether Cowboy B was aware of a substantial risk that he was just warned by Cowboy A and disregarded it, and that is the reckless mental state. I know it's technical, but I
see it.
Yeah.
We have problems.
I don't see that as an exotic theory.
No,
I mean,
I don't either. But what it does is it gets very close, I think, to straying from the purpose of the statement. So I will and do agree with you, insofar as to the extent I said it was of the speaker. I agree.
Okay, that's the only.
Okay. But the purpose for it remains as narrow,
Confined to the mental state. I completely agree with that.
right. So that'll be the ruling on order on motion 20. Motion 21 seeks to prevent the state from introducing testimony from Detective Trainer, speculating as to a methodology or the plan of any defendant.
I'm sorry, this is.
That's okay. 21.
Or 21. Yeah, that's fine. We're not going to try to introduce that, and that would be probably improper speculation. And any inference would be argument, not testimony.
I agree. Motion 21 is granted as unopposed. Motion 22 seeks to prevent the state from introducing as evidence or presumably displaying in any way Mr. Gibson's booking photo.
We don't intend to do that. It's not opposed. I probably don't even need to say this, but the only caveat is if some crazy argument were presented that isn't really him or something, maybe it would open the door to that. But I don't think that's going to happen.
Motion 22 is granted. The state may seek leave to reconsider if evidentiary circumstances.
Identity is not an issue.
I would always expect a booking photo to be sanitized, like the sheriff's office logo.
Of course.
Right.
But no such photo is. I'm simply barring the photo now, and if for any reason the photo becomes relevant in the view of any party, we will talk about it, and I would suspect everyone would want it sanitized.
Pretty confident we won't have to come back to this.
Even if a line under that says may not be used as evidence or something, we'll sanitize it.
Okay.
Motion eliminate 23 seeks to prevent the state from introducing any 911 or dispatch recordings without an appropriate foundation being laid. It's just a standard evidentiary.
I don't think we can admit any evidence without appropriate foundation.
Okay. To the extent this is a motion that argues that the court should enforce the Oregon Evidence Code, that motion is granted and is not opposed. I don't think the motion goes beyond that. Motion 24 seeks to prevent the introduction of testimony, comment, or argument relating to any prior bad act or arrests or convictions of Mr. Gibson. Maybe let's take those categorically, Mr. Hughey.
I'm not sure we actually need to break them down that finely.
Okay.
We would concede it subject to the door being opened in some way.
Okay.
Yeah.
So granted as unopposed, subject to door opening. Just to be clear, there are no qualifying convictions that would come in.
They're outside the 609 time frame.
Okay. MIL 25 asks the court to order the state to advise all state witnesses, not to mention, refer to, or attempt to convey to the jury in any manner, directly or indirectly, any of the facts mentioned in the motion. I'm not sure I fully grasp the scope of the...
Your Honor, sometimes counsel will go advise here's the court's rulings, and here's how the court got here, here's what we talked about, and then you have a witness gets on the stand and says, well, I'm not allowed to talk about that because of, X, Y, and Z. That's what this whole...
Don't refer to the rulings themselves.
Or the facts that were discussed.
You see the problem.
Yeah, okay, I see it.
Let me try to articulate what I think is being intended,
yeah,
which is,
thank you.
All parties should be admonished to admonish their witnesses not to discuss the fact of any ruling, or the fact that they are prevented from saying anything, and not straying beyond what they otherwise have personal knowledge of in their testimony.
Yeah, is another way of characterizing that. The parties need to admonish their witnesses not to, indicate in their testimony that they've been ordered not to say something.
And that's 24, 25, 26, 27, 20. The last, they all kind of just address this issue.
Okay. With my construal of 25, if I articulated it correctly, then I can see these as being appropriately granted and equally applying to all parties.
Yeah. I mean, it's this I was going to oppose construing it completely differently than I think we are now. I mean, the facts mentioned in the motion are all over the facts of this whole incident.
Right.
I don't think it's limiting that in any way.
I didn't mean it that way.
Okay. As I have so amended or construed by the court with respect to 25, is there any objection to 25, 26, 27, or 28?
No.
Okay. 25, 26, 27, 28 are all granted, are not opposed, and apply equally to all parties.
And if I'll just say for the other parties, if there's time, I hope to circulate our written witness instructions to make sure everyone agrees with them or doesn't think I've misinterpreted anything, and maybe circulate with the court as well.
Sounds productive. Would folks be okay just with a 5-minute brain clearing? Okay.
Yeah.
I'm seeing nods. Let's take 5. We'll come back at 1:45.
Yeah. Ponte already filed a motion to set aside his conviction.
I'm going to go that way and hit the restroom.
parties are present. We're outside the presence of the veneer. Does anyone wish to be heard?
I had asked to revisit the issue of motion in limine, Defendant Gibson's motion in limine number 20, Your Honor. Obviously, we were just talking about that. It was all related to the speech component of taunting or provoking a fight. The court's ruling was that any of that evidence would be very strictly confined to its relation to the mental state element in the crimes. And then during the break, we were notified of a notice of self-defense, and it occurred to me, and actually I think the court sort of anticipated this as a hypothetical. It occurred to me that that would then generate another theory of relevance for that evidence as it relates to whether someone can validly claim self-defense if they're the initial aggressor. So that would be, in my view, another category that it could be strictly confined to.
Okay. And that, of course, is only if the defense is actually raised with the jury.
Certainly.
Okay.
Yeah, I can't defend something that isn't being.
Okay, just making sure we're clear about that. I think that is right. Does anyone want to be heard about that? Just to boil it down, the argument is to the extent that Mr. Gibson has now provided notice of possible intention to assert a defense of self-defense, that the state believes it should be allowed to use taunting words it attributes to Mr. Gibson as evidence that Mr. Gibson was the initial aggressor, which would be a way to overcome the self-defense defense.
Well, yeah, we would not concede that that is a lawful argument for them to make, because the First Amendment ramifications to that would be shocking. But my understanding of first aggressor law is you have to be the physical aggressor, not the person who says things. And so with the court's very limited caveat of you can infer from words, you can infer the intent of actions, which is, I think, the limited purpose. That doesn't change anything. It doesn't change the court's ruling. But to say, oh, well, he wasn't defending himself when he held a hand out and backed away because he had said things that were rude earlier, and therefore he is the primary aggressor and loses his right to claim self-defense. I don't think that that's supported by any case law.
Does it turn on what he says? Does that matter? I'm not attributing anything in particular to Mr. Gibson, but if a person says, "I'm about to punch you in the face," that.
So I understand the court's point that there could always be a factual scenario. Yeah, I'm about to punch you in the face, and then you move.
And the other guy gets the punch in first.
But then what really is happening is you're using that language to infer from them cocking their arm.
Right.
Okay.
Right.
But we're not in a factual vacuum here where that's the case. And he didn't say, "I'm going to punch you." In fact, what he said was people should de-escalate, be nonviolent. Go ahead and let them be violent, but not us, and don't jump in. Those are the things he said.
Okay.
So in the factual scenario we have, I don't see how his language denies him a right to self-defense.
Okay, thank you.
It's a strictly factual question. It's 161.215 sub 2, and the question is one reserved for the fact finder.
And what is reserved to the fact finder?
Whether or not the speech or conduct makes the person the initial aggressor. I don't, Mr. Lee is not correct that words, no matter how provocative, simply cannot take somebody out of self-defense under 161.215. That's not correct.
I agree. That said, sorry.
I wanted to provide some authority.
Go ahead.
State versus Phillips, 313 Oregon App 1, quote, "We agree that," internal quote, "provocation by mere words, if unaccompanied by an overt act of a hostility," end internal quote.
Yeah, absolutely the correct legal controlling
Okay.
interpretation of 161.215.2.
Okay.
So thank you for the authority. It is the right authority. I agree that words can be used as part of the fact finder's determination, so long as they are accompanied by an overt act of hostility. So that doesn't take the words out. What it potentially does is make a later motion ripe that you do not believe there is such an overt act, such that the state should be able to argue that in closing. That's a motion to be brought once the evidence is in, and once we know what the record is.
So is the court modifying?
So I'm modifying the order on 20 to include that it may be used in arguing initial aggressor if Mr. Gibson puts forward a self-defense defense. So long as it meets the legal standard.
That there is an overt act of hostility?
Correct. Okay, I think that brings us to motion 29, and only because it was filed a while ago and things have happened since, let me ask first whether motion 9 is still ripe.
Sorry, 9 or 29?
29.
29. Oh, well. Our view would be that it should not be right because the defense has every word captured on every recording that's identified on our exhibit list.
Have you provided an exhibit list?
Yes.
Okay. That was still
I'm sorry.
That was still in train last time this issue came up on the record.
You're right. I'm sort of assuming the court, imputing course knowledge to the court that it doesn't necessarily have. But,
very dangerous.
Yeah. And now it's even further narrowed after those earlier rulings that struck 6 and 7.
Okay.
The bridge videos.
Okay. So is there still relief that Mr. Gibson is seeking in 29?
Yes, Your Honor. And the reason for that is two of their witnesses lay a factual foundation. Two of their witnesses, their lay witnesses, Justin Allen and Frederick Sappi, if I'm pronouncing his name correctly, were in the bridge group. And so they were with that group of people in the bridge. And so even though the video's out, all the statements that are on the video, they could still potentially be.
And those are statements that these folks would say they heard not from Mr. Gibson, but about or attributed to Mr. Gibson.
Right, but then also other statements that are not captured on the video, because the video is most of the universe of statements, but not all. And so my concern is, even though we're on notice of what's said in the videos of the two bridge groups, for example, that Mr. Allen or Mr. Fauci is going to come in and say, oh, well, it's not on the video, but let me tell you what else I heard.
So motion 29, though, is only about statements from other co-defendants, right?
Right.
Who were on.
And Mac Lewis, Mr. Lewis was in the bridge group.
I see. Okay.
So he was walking, associating with them.
Okay.
On the bridge. They had undoubtedly interaction with him. Okay. That is not documented. Okay. It may be something they want to introduce. Just to give you a scenario, I don't think that this is going to happen exactly. But Justin Allen could get on the stand and say, well, I was on the bridge with Mr. Lewis, and Mr. Lewis, when I turned my camera off, told me Mr. Gibson said this.
I see. Okay.
Thanks for letting me flesh it.
No, I appreciate it. I see it. So it's not a Bruton issue, because it would be somebody else's testimony about what Mr. Lewis said about what Mr. Gibson said.
Yeah. I sort of was interpreting it as a Bruton
issue. Okay.
Is that the authority? I mean, I don't see any other basis for the authority.
Well, but
the party opponent is not hearsay.
I'm not reading 29 as a motion to exclude. I'm reading it only as a motion that the statements be provided.
Well, I mean, then that's a discovery motion, which if they're not memorialized and they're not in our possession.
I'm a little lost in this motion, I will admit. So the defendant's concern is that some statement will be attributed to Mr. Gibson and you haven't heard about it yet.
Yes, Your Honor.
Okay.
And we had previously moved for that, and it was deferred.
Right. Okay. And the state's response is, you're not entitled.
I don't anticipate that happening. I don't think I'm aware of a statement by a co-defendant attributing another statement to Mr. Gibson that isn't captured on video.
Okay, you just don't think that evidence will be forthcoming?
Right.
Okay. Nobody, so in Mr. Lee's scenario, nobody who's going to say, I was on the bridge with Mr. Lewis, not to pick on Mr. Lewis, Mr. Lewis told me so-and-so about Mr. Gibson.
Right. That's correct. I don't think that is going to happen.
Okay.
And
If that is going to happen, it will not happen without giving the court a heads up first.
that is what I'm noting in all caps.
Okay. So the rule is going to be that we're not going to hear that evidence unless everybody knows it's coming and we can talk about it and decide what to do about it.
And I'm sorry.
So I think as a formal matter, I'm denying the motion, but I'm making that the rule of play.
And just to be clear on when we say this is going to happen, when we say this, we're talking about one co-defendant or a witness introducing
A statement of one of Mr. Gibson's co-defendants.
the co-def that attributes something to Mr. Gibson.
I think full stop.
Okay. Okay. I mean, I think, yeah. I could see a scenario where that is implicated, but it's very innocuous and doesn't relate to Mr. Gibson in any way.
Okay.
Certainly, we'll still do our best to notify the court.
Okay.
And we'll be much more vigilant of something that implicates or attributes something to Mr. Gibson.
Okay. So state will give a heads up outside the presence of motion to eliminate 30 seeks to exclude the introduction into evidence any guilty plea statements or evidence of convictions with respect to people who were charged co-defendants in this case.
We would concede with the only reservation being unless the door is open in some way, which we would address the court.
I agree. It's granted as unopposed, understanding a door might be open. Motion to eliminate 31 seeks to exclude evidence that I'll just read the motion verbatim, that one or more extreme right groups typically align themselves with a group called the Patriot Prayer.
Court want some.
Yes, please.
Detective Trainer, in his reports, made that assertion. And so my concern is that he's going to get on the stand and say, Proud Boys, for example, or I think 3%ers were mentioned, though they affiliate. And so it goes to the extremist motion that we've already discussed today,
Yeah.
but it's a little more specific and it's
Okay.
drawn directly from Detective Trainer's report.
Okay, thank you. Is the state intending to go there?
Can I have just a moment?
Sure. Go on, Dorothy.
Yeah, that.
Gee,
We are fine conceding 31.
okay, 31 is granted as unopposed. Motion to eliminate 32 seeks to prevent the introduction of evidence from the first 10 minutes of a video exhibit that's called Unedited Version
Is that the one?
Millsap Stumptown Matters.
And if you give us a moment, that may be the
Sure.
one that they've already
Yep.
withdrawn. I'm not sure.
That's not.
No,
It's not, okay.
No.
Okay. Then, Your Honor, this is one where we've got the two from the bridge group that the state's conceded, and then this one is one that the first 10 minutes of is, again, the bridge group. Mr. Gibson's not there, Mr. Schultz is not there.
It's not on the bridge, but it's
It's that group as they approach the cider bar. And that's a video that if I were prosecuting Mr. Kramer, I would definitely want to prosecute Mr. Kramer. But it's got nothing to do with Mr. Gibson and Mr. Schultz. It's full of statements about Mr. Gibson, and so that goes into some of the earlier rulings. And it's pretty prejudicial to our client because it shows Mr. Kramer kind of ramping himself up, and we're not even a part of that. So that's the motion there.
Thank you.
We think it's admissible, Your Honor, and it's not appropriate to grant the motion. The reason it's admissible is because Defendant Lewis is part of that group and in that video. So it may be appropriate to instruct the jury that its use is limited, and that'd be a jury instruction question.
Okay.
And then if there's other questions about redaction or trimming, that would be maybe tailored to that exhibit. But I think for this motion, it should not be outright excluded.
And is it about 10 minutes?
What's the total length of that?
Well, 10 minutes is where Gibson shows up.
The video is longer than 10 minutes.
Oh, the motion is only directed to
Right.
those first 10 minutes.
Right.
Okay.
Then the videographer walks over, and that's where Mr. Gibson and Schultz are seen coming over.
Okay.
That
Okay.
we don't object to.
Okay. Okay. So the only moment for decision is the
First 10 minutes.
the first 10 minutes. Okay.
Just to throw it out there, I'm trying to remember which defense attorney that there's another. In this case, Judge, there's a lot of different video from a lot of different perspectives. Often there are multiple people in close proximity.
Right.
Someone has an exhibit that they were intending to offer that actually is very similar in video to this, where it overlaps. Do you guys remember who it was? It was on the exhibit list of one of the defense attorneys. It was either Noah Caudle or not Noah Caudle. What am I saying? It was either there's one of the young men that's there confronting the bouncers at the door.
Noah Buchal?
Yes, it was. I think it was out. I don't remember which witness list he was on, but it was one of you guys.
There is an issue, there is another issue with this exhibit. The file size is over a gigabyte. The state's exhibit had some extraneous stuff in it and had been re-encoded in a way that interfered with one's ability to jump from place to place on the computer.
Oh.
So
You could only watch it sort of
Right.
all the way through.
So I had emailed, or we transferred to Mr. Hughey the original version as posted by the videographer without that, although it does unfortunately have something on the first second that says it's an exhibit to my declaration. And I was suggesting that we use that one again, but I didn't intend to include the first 10 minutes.
Okay.
We have some,
Okay.
If we can all agree on the one video to use, we're happy to do that so that we're on the same page when we have multiples. But
To be clear, the state, I just want to make sure I'm understanding the state's position correctly, which is that the first 10 minutes is admissible, although potentially only in Mr. Lewis's case.
Correct.
Okay. I need to see it.
Potentially.
I'm just going to reserve on this for now. I'm going to need to see it.
Okay.
I have it, I can cue it up.
So we can, I don't want to do it right now.
Yeah, let's defer all the exhibits till this afternoon, maybe.
So he's on my witness list, that doesn't mean that's gonna.
someone sent me.
Play that part.
Okay.
So I'm just going to defer and until I've seen it, and then we can talk about it.
That's that guy.
Should we note reserved,
Yeah.
however, state must make an offer of proof before admitting?
We're going to do it.
Okay.
That motion will be resolved before we begin trial.
Okay. Thank you, Your Honor.
Okay.
Motion 33 seeks to prevent the introduction of testimony or argument regarding, and I'll read verbatim, that in the past there's been violent tendencies between the two groups.
And again, that's directly out of Detective Trainer's report. Or I'm sorry, Ciuda's report.
We oppose this motion, Your Honor, not because that evidence is relevant for the truth that it asserts, but there is a theory of relevance that it's why now Sergeant Ciuda wanted to go over there in plain clothes and observe things after he heard that there was going to be a confrontation, because he knew there had been clashes in the past, but certainly we would have no objection to limiting that evidence to that purpose.
Not for its truth.
Right.
Okay. I think that's a better way to resolve it, which is that evidence doesn't come in for the truth that there were clashes, but to this witness's belief there had been clashes, which explains why the witness did a thing.
But, so the first question is, why is whether or not the officer was in plain clothes relevant at all? It doesn't matter to this case. It doesn't address any probative fact to any element. And there's no chance that the jury is going to actually.
If I can thread this needle. Would there be an objection to the witness testifying, I went over there because I thought there might be something happening, there might be trouble?
Mr. Buchal asked the question, why can't he say, I heard reports that there was something going on? I mean, I think.
So I don't know the factual background here. Is this somebody who was there
No, he
before
was.
things happened, or?
He was, on May Day, he was downtown. So this is,
Okay.
Officer Souede was downtown for the immigration or ICE protest.
In plain clothes.
In plain clothes. And then he was notified, hey, there's something going on.
And then, okay.
And so then he went over there and he observed from a distance.
Okay.
I'd have to double check. I think actually he overheard that people were going to go over there and was like, oh boy, I think there might be problems. I'm going to kind of follow along
Okay.
Okay.
and
So-
watch.
So again, what would that have to do with violent tendencies in the past?
No, that's the thrust of my question. I mean, he can certainly say I went over there to see if something was happening.
I think we can probably just avoid this by ensuring, by just instructing Sergeant Ciode to explain that it was out of concern and sort of excise to what happened in the past.
I agree. That'll be the order with respect to motion 33.
So it's granted?
Sounds like in part.
It is granted. Yeah, so it depends on how broad you intended the scope. If the scope was he can't talk about clashes in the past, it's granted.
That's my concern.
Okay, in that case, it is granted.
Okay.
Motion 34 seeks to exclude testimony or questions asking if there's a chance for hostility, quote, to break out from either side. I think it's a similar.
I mean, I think this question almost seeks to bar the solution we just reached on the prior one.
We'll withdraw this one. Based on the prior ruling, we'll withdraw this one.
Okay, thank you for being productive, everybody. Motion 35 seeks to exclude testimony or questions asking this particular witness whether he was in a park earlier that day and whether he'd observed a group of men he later observed at the Cider Riot protest, and specifically if he overheard a conversation among that group that they wanted to fight the Antifa group for the purpose of fighting him. That's a quote from
A
that.
little factual background.
Sure.
So what the officer writes in his report is that, and what he testified to in the grand jury was that he was at that downtown protest. He observed a group of people that, for whatever reason, he associated with conservatives or patriots or whatever, but he did not recognize any of them. Mr. Gibson was not a part of that group. And those people are talking.
So the they in your motion is talking about those people, or are they attributing things to Mr. Gibson or to Patriot Prayer?
And he overheard those people say, "Oh, we're going to go fight Antifa at Cider Riot."
Okay.
And that's
Us guys who are standing right here.
us unidentifiable guys that are not Mr. Gibson who are standing here.
Okay.
I don't know who they were. May have been people in the bridge group. I just know that Mr. Souede knew who Mr. Gibson is, and Mr. Gibson wasn't one of those people.
Okay. Okay.
I think this can be addressed in kind of a similar way where he can be confined to saying he just overheard people talking about going to Cider Riot, not the verbatim, we're going to go fight them or we're going to go fight Antifa.
Okay. So nothing about fighting, just he overheard people saying that they were going to head that way.
That works.
What is the relevance of that unidentified group of people saying they're going to Cider Riot? And again, the factual scenario is that you have a group of people on the patio at Cider Riot and another group of people coming to them.
Which we're going to see on video, right? I mean, maybe not this group, but that's the scenario we're going to visit in our video evidence.
Right, and that's undeniable. So what does him overhearing this conversation from unnamed people have to do with any element the jury is going to find in this case? None, and it's just a way to, that's the group that had a plan.
Right. So I mean, I think it helps explain why a witness did a thing, which goes to a jury's ability to evaluate that witness's testimony. So, Mr. Hughey, are you suggesting that this witness would simply say he overheard people saying that they were going to go over to Cider Riot, and that is why Cider Riot was on his radar?
And why he followed along and observed.
Okay.
Yeah, it's almost the same, I think, as 33.
Making clear that none of those people are defendants in this case. Okay,
Right.
He cannot.
Yep. And you certainly can't introduce statements about, there's going to be a fight for its truth. And if the court on a 403 rationale wants to just cut that out, that's fine too.
Which part?
Like that there was going to be a fight.
Yeah, no, so that is out.
Yeah.
On 403, I can make a bigger record if you want, but I think we're all agreed that is out. The real question is, can the officer say he overheard people saying that that they were going to head on over to Cider Riot and he decided to follow along? He can say that. I think that's important for the jury to hear. I think it's relevant to their ability to assess this witness's testimony in full. Nothing about fighting, nothing about intent to engage in violence. And certainly not either, well, you could get this on cross, but he cannot affirmatively say that it was any of these three people, and certainly you can ask on cross that he can identify any of these three people as the people involved. Motion 36 seeks to exclude evidence or question of this witness regarding what he heard on a police radio.
I think this is almost the identical motion, that if you heard, hey, we heard there's a group going over to Cider Riot, well, I'm going to check that out. But the substance of it should probably be excised.
Okay.
Yeah, I don't have a problem with them laying foundation for why I walked over there.
Okay.
I heard there was a thing.
Yep.
What I don't, there's a lot of radio traffic though, and I don't want, and then I heard this and this and this.
Okay.
So.
I think I agree with that. The fact of a radio call is permitted. Do you think you need the call itself, Mr. Hughey, or just the officer relaying?
No, we don't. It's not on our exhibit list.
Okay. So the fact of a radio call, that something was going on, but nothing about violence and nothing about detail.
Yeah, I think that's fine.
Okay, that'll be the order with respect to motion 36.
The court said can't talk about violence and can't talk about the substance of the call.
Right. I don't think that's the word I used, but it was the intent behind the word I used. Welcome back. We're going to finish motions and then do jury. Okay, so 35 and 36 granted in part along those lines. Motion 37 seeks to exclude testimony that Justin Allen or any defendant was at the ICE demonstration near the ICE facility, or that they were on the bridge, which I understand is the bridge that you've mentioned earlier.
Yes, Your Honor.
Okay.
If the theory is that somebody else coming from a demonstration that related to ICE is somehow more prejudicial or has a risk of unfair prejudice that substantially outweighs its probative value, I don't think I understand that analysis at all.
I need the background. Why? How does this evidence come in?
Unless Mr. Lee thinks differently, it's basically just where Mr. Allen first connected with people, where he walked to Cider Riot from, and where he began filming.
And again, you guys know more than I do. Who was Mr. Allen with?
So he is a guy that was with, like what we would call the sort of more right-wing group, and at the time purporting to kind of be aligned with their views, and then filming for the purpose of
But who,
documenting.
I think I heard you say he walks over with people. I don't,
Right.
Can I give some facts?
if you would.
Yeah. So, Your Honor, earlier in the day, there was a anti-ICE protest.
Right.
And a lot of people went to counter-protest the anti-ICE protest.
Right.
So if we start getting into Mr. Gibson was there with Mr. Allen and they were counter-protesting the ICE protest, now we get into all this stuff about immigration policy and people's views on immigration and, oh, you know, you were counter-protesting the ICE protest because you're a xenophobic, whatever. And it just gets into a whole can of political.
Okay. So no, it's not Mr. Allen's presence that's the problem.
Well, Mr. Allen's presence is always with either the bridge group or Mr. Gibson.
That's the part I'm trying to understand.
Yes, and I'm trying not to get into, oh, well, any of these defendants were counter-protesting the ICE protest.
Okay.
The other kind of theory that the state has is certainly not to get into the merits of ICE protests or any side on that, but I think it is important that there be evidence that that protest had essentially concluded, or at least there was an interruption, and then there was a movement to Cider Riot, which was a totally different thing. It wasn't like spilling over from a different protest.
And I don't have a concern with them saying there was a protest, but when we get into the content of the protest, that's where it becomes an issue that can prejudice my client. You know, there was a protest of various forms downtown for one of the many number of reasons people protest. There were people there on both sides. That's where I saw this person. Okay, fine.
Maybe I would propose that the court order no testimony, seeking to describe the merits of that earlier protest in any detail.
I think we can say it was, so I think everyone can agree there was a protest downtown earlier. Mr. Allen was there, Mr. Gibson was there. I don't know if other defendants were there, but, and then that there was a lull or a stop to that protest, and then this is what happened after that.
Yeah.
Okay. Mr. Hughey, does that meet the state's needs?
Yeah, and so I just want to be careful that I am more mindful of what we can't say than what we can.
Right.
What is disallowed is that it was an ICE protest and somebody was against it, somebody was for it.
That's going to be the order.
Okay.
So it's essentially granting in part as to ICE.
Okay.
So no reference to ICE. And obviously Mr. Allen will have to be so admonished.
And we will do that in the written. Sure.
All right, as we move along.
That's more facts.
Let me make sure I articulate the motion and then you can tell me what it means. Motion 38 seeks to prevent the introduction of testimony through Mr. Allen that the group that he was a part of was waiting for reinforcements, and specifically that they were waiting for Mr. Gibson to show up before they went over to Cider Riot.
Yeah, so, and Your Honor, this dovetails with the earlier motion on the two bridge group videos. The videos are out. What I don't want Mr. Allen to say is, well, and I should tell the court first, Mr. Allen and Mr. Gibson didn't know each other. There's no evidence that they knew each other. They didn't have any communication with each other. But Mr. Allen is in this bridge group and he's talking to other people. What's going on? Where's Gibson? And when are we going to go over to Cider Riot? What are we? All this stuff about their group. And then there's talk of, oh, I hope Gibson shows up with 10 other guys or something like that.
I see.
Okay. Which of course is not what happens, but.
Okay.
This one's a little more nuanced because Defendant Lewis is part of that group. And so the talk about, in parts of this video, it almost appears that group is in ways sort of surveilling Cider Riot and deciding when to move and maintain the element of surprise and things like that. And that weighs, in our view, pretty heavily on the knowledge that Mr. Lewis may consciously disregard with respect to a grave risk of public alarm. So I think I would propose that the way to handle this motion is in a limiting instruction, that it may not apply to the conduct of Gibson, defendant Gibson, I should say.
Or Schultz.
Yep. If you're joining,
And even what the nature of the conduct of Mr. Lewis is, it's our position.
It's Exhibit 5. I just couldn't hear you, but not your fault, Mr. Doyle. It was just crossed off. Say that again.
Well, it is our position that even as to Mr. Lewis, that the conduct that he is very passive, that not that he was inciting or everything, but he just wanted to take his camera and film what was going on. However, and this is going to come out, I believe, is that in his backpack, he had a flag.
Okay.
Your Honor, I should have articulated earlier, this is not just limited to relevance, it also has to do with hearsay. So Mr. Allen, the subject of this motion, would not be testifying
That he was waiting.
that he was waiting. He would also not be testifying that Mr. Lewis told him, I'm waiting for Mr. Gibson.
It would be somebody else.
It would be somebody else. And so it would be hearsay and totally irrelevant in addition. So whether or not some other non-charged person had said that to him, total hearsay.
Right, I mean, that's exactly the way I just explained why it's admissible and important with respect to Mr. Lewis, is that there's basically a group sort of waiting to go over, and amongst the chatter that Mr. Lewis is taking part in and most importantly hearing is, should we wait for reinforcements? Are they going to see us? You know, that kind of thing.
And that informs Mr. Lewis, the question of whether or not Mr. Lewis recklessly disregarded.
Absolutely. Absolutely. But I think this can be addressed by instructing the jury that is its limited purpose, just as we do anytime a hearsay statement is offered for a non-hearsay purpose.
And the issue with that, Your Honor, is also, we can play the video, and maybe I'm wrong, but I don't think the video shows Mr. Lewis engaged in that conversation or even in frame when those other people are having that conversation. So I think the state, to even pursue a hearsay exception, would have to lay a foundation that Mr. Lewis.
I agree. This is out subject to a 104 hearing, where we can establish whether or not there's a foundation that was Mr. Lewis's view of things, that he would have heard the things, not that it's his view. That was exactly the opposite of what I was trying to say. That he had heard those things and that he knew that was what was sort of going on at large.
Okay, I would suggest then, as we go through the exhibits, which I think we're all kind of contemplating doing this afternoon, that we treat that as an offer of proof for that 104 hearing, and the court can maybe make a decision.
I'm happy to receive an offer of proof through the exhibit itself.
Yeah, thank you.
38 is deferred.
Your Honor, may I take a point of personal privilege for about 4 minutes?
Certainly. We will take a 5-minute break. We'll come back at 11:40. Just so everyone knows, I have to stop at 12:05, and then we can resume in the afternoon with wherever we are.
Okay, so since they're going away for a few minutes, we're going to go ahead and go to AFK, turn the music on. We'll be back soon.
Which exhibit is that of ours that we said no?
Number
Number 2.
we'll go on.
Sure.
Okay. Anything to take up before we get to the next motion? Okay.
Well, yeah, maybe. Actually, I'm sorry, Your Honor. There was some talk off the record of the application of ORS 136230.
Sure.
And whether it requires the in-person attendance of the veneer at the time peremptory challenges are being made. I don't know that any party is moving to have the court enforce that interpretation. But if any party is, now might be a good time so that that could be addressed sooner than later.
Sure, I'm unaware of that interpretation, but I'm happy to hear from anyone who wants to be heard on it.
This isn't necessarily going to be a big deal, but the statute 136.230
Sure.
requires both parties to agree to taking peremptories outside the presence of the jury.
Correct. The universal practice in Multnomah County is that agreement is sort of standing, and
Right.
someone has to speak up if they don't want it.
And I was late, so I may have waived it when discussions happened.
It was not had. Candidly, it was presumed.
My concern is when we're dealing with the number of jurors that we have.
Sure.
Confusing, and they're all wearing masks. I've read all the questionnaires. There's a lot of information. My concern is confusing a juror or not remembering a particular juror. I will say my concerns are lessened with this handy cheat sheet that we have.
Are you asking me to call the entire remaining veneer back, Mr. Schmunzes?
I am asking if that's even possible.
It is possible. We won't get all of them. I'm confused by your potential confusion. You have questionnaires and numbers and detailed voir dire notes. You also have seating charts that tell you where each of that person was sitting with their particular number on that particular day. I can assure you, as we work through jury selection, we will go as slowly as we need to, and to make sure that everyone knows which is the juror that we're speaking of. But I'm hard-pressed to imagine that having 80 people masked who cannot all fit in this room at the same time, so we would have to go into camp to some other room, would significantly improve the chances that you don't make a mistake. We'll make sure that no mistakes are made. Does anyone else wish to be heard or have a request?
Well, I think that we decided how to do that, and I'm fine with that decision. But what I would like to, because we have so many attorneys on the right side, and at least a couple of attorneys on the other side, that we would be able to, as we go, confer among us.
Absolutely, of course.
Because that's very important, because I'm going to say, I'm going to strike juror number 2002. Notice that's outside of our, and then they say, well, no, you don't want to, but you want to do 2010.
Right.
And if we can confer, I think that will lessen the issue that Mr. Sponsi's raised, which makes great sense, except because of the number, there's no way that it'll make it any better.
I agree. To be clear, what I was going to say, so I'll say it now, is we will go as slowly as we need to. Parties may take whatever time they need for defendants to speak with their lawyers, for lawyers to speak to other lawyers, for defendants to speak to other defendants. I've got no problem with everyone consulting and conferring and working through this. I think the question, Mr. Schmonsi's raised two issues. One is whether or not we need the actual jurors. I don't know of authority, and I don't read the statute that way. The second is whether anyone does not do what I thought they were doing, which was stipulating to taking peremptory challenges orally. If someone wants to not stipulate to that, we can do it in writing. I suspect that will be more confusing. And of course, in doing it in writing, all that we're really doing is handing it to me, and then I hand it to someone else.
The only reason to do it in writing is if the jury was here, and that creates a subterfuge. You don't know who's striking who.
Right. Okay. Does anyone want to be heard on any of these issues, or does anyone disagree with the process as I have laid it out?
I just want to state the state's position for the record is that I'm not confident that 136230 is correctly interpreted to require the in-person appearance of jurors, and even if it were, the state is not advocating for that and would waive that interpretation, even if it could be construed that way. But I think it is important that the parties make it known if they want it to be now.
It's the question that I've asked. I will ask it again. Does anyone disagree with Mr. Hughey's position?
Just on behalf of Mr. Gibson, Your Honor, I would say that this issue is a exceedingly new issue to me, primarily practicing on the other side of the water, and I haven't had a lot of time to contemplate this statute. I first read it today, but with the court's assurances just now that we'll have plenty of time to go through everything, and those assurances go a long way. So.
Okay, I think I've heard from everyone that I don't think anyone is asking us to do something different, so that is how we will proceed.
I don't mean to quibble here, but is counsel for Mr. Gibson making the request or waiving it? Because all I heard was the assurances go a long way.
Sure, I understood that there was a waiver.
Yes, Your Honor.
Okay.
I thus understand that there's a stipulation to taking peremptory challenges orally and an agreement that whether or not ORS 136230 might mean that the presence of the veneer is required, which is not how I read it. Even if that's what it meant, no party wishes for that to happen in this case, and all parties agree that no one is prejudiced by proceeding, as we have talked about several times over the last several weeks. With that, we will turn to motion 39, which seeks to prevent the introduction of Mr. Allen's testifying that the Bridge Group was hoping that Mr. Gibson would show up with a bunch of large men with him. I think it's the same issue. It needs to be resolved the same way as the previous motion, and so it is deferred until there can be an offer of proof. Motion limine 40.
It's basically the same issue.
Okay, I was just reading through the subparts. Okay, so 40 will be deferred on the same basis.
Mm-hmm.
Is 41 the same or different?
It is different, Your Honor,
Okay.
because
So 41 seeks to prevent the testimony from Mr. Allen that the intention of the protest, I think that means the people on their way to who arrived at Cider Riot, was to get someone to throw a first punch, and then all hell could break loose, but it would be the other side, quote unquote, the other side's fault.
and this is arguably subject to the more general ruling that the court put in place on motion in limine number 3, but motions in limine are much more effective the more specific they become, and so that's the issue here.
I'm rereading motion 3.
I think at the beginning of this set of motions, we had
Oh, I think we started with 4.
we're on set 3.
Oh, I see. I'm sorry. You're pointing me to the right place. I'm sorry, Mr.
And
Lee.
I was
Thank
just
you.
saying that we
Yep.
had a summary of
Yep.
the court's ruling. I could be wrong.
Okay.
Yeah, there's not, I think that would be speculation. There's not an objection to that.
Okay, Mr. Allen doesn't have that personal knowledge.
To characterize somebody else's intent
Okay.
completely.
So MIL 41 is agreed to, or is granted as unopposed. Motion 42 seeks to exclude testimony from Mr. Allen and also argument from an attorney that Mr. Gibson and other defendants were taunting or provoking using such characterizations.
This one we oppose, and it's different from the other motions that touched on elements of the crime or terms of art that have specific legal definitions relevant to the elements. These are just words in the English language, like running or jumping, that we use to describe conduct and it can be,
Well, it's a lay opinion, right? Because
Yeah.
because unlike running or jumping, it involves at least in part the intent of the alleged taunter or provoker, unlike running.
sure, but it's a lay opinion that can be testified based
Why
on the
is-
rational perception of the,
And that which leads me to why is this witness's lay opinion based on his rational perception relevant in this case?
because for the same reason that we were just talking about all the taunting, as it goes to mental state for the risk of public alarm.
That this witness's opinion that I don't. The jury will see everything this witness saw.
Almost. I mean, not necessarily. I think there may be some areas that are out of frame or, in between videos or whatever. But your point is,
He can testify to what he saw. He can testify to a reaction to what he saw. I'm not going to allow Mr. Allen to testify to what the intent was by the person alleged to be the taunter or the provoker. So motion 42 is because I don't think that's relevant. And if it is relevant, I think it is unduly prejudicial to when this person had potentially not as good a vantage point as the jury had. So motion 42 is granted over state's objection. Motion 43 seeks to exclude a testimony from Mr. Allen that Mr. Gibson is the leader of Patriot Prayer or any other group. I think this is covered. And is
We did it earlier as a general matter.
Okay.
And this was specifically to Mr. Allen in case the earlier motion failed.
Okay. So same ruling on this as with the earlier.
do we have that other motion number handy?
It is motion number 19.
And so the ruling was granted in part.
Granted in part as to actual leader.
Yeah. Thank you.
And of course, any testimony about perceived leader needs to be contextually relevant. There might still be an objection on that ground at trial. Motion 44, I'll read verbatim. Motion to bar the state of Oregon from introducing testimony from Justin Allen that the bald-headed male who engaged in a mutually agreed boxing match with the Cider Bar doorman was somehow associated with Gibson or the Patriot Prayer group.
Or want more facts?
Let me see what the state's position is first.
We do oppose this, and this is, I think, subject to proper foundation, appropriate. This is the context of this, Your Honor, is basically there's a one-on-one, street brawl. I'm sure the court has watched it. I sort of describe it as like each side putting forth their champion, in a way, and so it's kind of bizarre, I think, that there's a motion to oppose somebody characterizing that way when it's blatantly obvious. But if he can lay the foundation for why he thinks that,
Okay.
what side he came from, who he fought against, that sort of thing, I think it's perfectly admissible.
Thank you.
So Mr. Gibson and Mr. Schultz arrived by themselves. Mr. Allen is in this other group. The bald-headed male is in the other group. There's nothing in any of the videos showing that they were associates or part of Patriot Prayer or anything like that. He's one of many people at the protest. And to say that he's associated with him or connected with him somehow, he would have to have heard that from either A, Mr. Gibson, okay, but we know he's never spoken to Mr. Gibson, or B, the bald-headed man, which is hearsay. And so how do they conceivably lay the foundation for that?
Maybe I was misinterpreting the motion. If the motion is to prevent him talking about any association beyond the way these two groups sort of, sorted themselves out in that incident, I don't have any opposition to that.
And so, but I don't know what the facts are going to be. He might say he saw the two, Mr. Gibson and the fighter, talking. He might, I don't know, but at bottom, I think we're all saying the same thing, which is this would be admissible testimony only if there's an appropriate foundation laid. So the motion is denied because if there can be such a foundation, I think this evidence is relevant, and I don't find that it is that any undue prejudice would substantially outweigh the probative value. If there cannot be that foundation, if it is not based on personal knowledge, then I agree it should be excluded.
What kind of foundation are we talking?
Motion 45 seeks to prevent the state from eliciting testimony from Detective Trainer related to what went on at Cider Riot beyond what can be observed in the video exhibits. I think on the basis that Detective Trainer was not present, so anything he saw comes from the videos themselves.
Yes.
Right. And we don't oppose the bar on Detective Trainer just interpreting what can be viewed and interpreted by anybody.
Which was the earlier ruling.
Right.
Okay.
Right. The only, I guess, caveat would be if he has knowledge, like for identifying parties that he's had contact with or identified through some other way. Here's that person in the video, but you can't say what they're doing or why they're doing it, that kind of thing.
I agree with that. And sort of 45 is granted as unopposed on that basis. Motion 46 seeks to.
I'm sorry, Your Honor.
Sure.
Okay. There's a kind of subpart to this is that there's a massive library of videos in this case, and the motion also seeks to prohibit him from testifying about the videos that he's seen, but that are not being introduced at trial. Our concern is we don't want him to say, here's 4 videos, and by the way, I saw these other ones, and
I see.
Those videos,
Okay.
X, Y, and Z.
That's what they did in federal court.
Mr. Hughey, is this a thing?
I don't think so. Okay. We're fine with that.
Yeah, that makes sense to me, and that to the extent that I now understand the motion encompasses so broad a scope, the motion remains granted. Okay, folks, I gotta call it. I'm sorry. 120 to resume. Okay, let's plan on doing jury selection at 120. When we've completed jury selection, let's return to the motions, and if we have time to do offers of proofs, let's do that as well. Thank you all.
kind of feel silly asking, but they didn't break for lunch, did they? I stepped away from the computer for an energy drink, and they're off the record. Oh, I thought he said that was at like 12:45. I guess in that case I'll put the music on. Resuming at 1:20. Okay, thank you. I guess that last motion was really quick and they decided to break there. So, yeah, so I'm gonna go ahead and, just because stuff is like set up perfectly, I'm gonna leave the stream running with the music on and be back at, oh wait, so jury motion, okay, if it's jury selection at 1:20 and then motions after that, is that what I'm understanding? Because that's going to determine if I leave the stream running over lunch or if I shut it down, because... Okay. So yeah, if the judge said we're doing jury selection after lunch, then motions after that. Because the jury selection is not going to be live streamed, and we don't know how long it's going to be, I will go ahead and shut down my stream, and hopefully I should be getting notice from the court clerks about when they're finishing up jury selection so that I can be back for the second half of motions. Things go right, we'll be able to get those sorted out today, then get the trial started tomorrow morning. In the meantime, definitely thank you everyone for, definitely thank you all for joining in. I know this was kind of the boring side of things, but still helps to understand where the sides are coming from going into this, and we'll see going from there what happens. So yeah, if you want to see more of this, definitely give us a like, follow, on whatever platform you're watching on, and we'll get notices out when the next session starts up. Y'all have a good day, and talk to you later.